Hello and welcome to Levi Salomon's series of videos on civil liability law in Brazil. By now, you have already watched the first video of the series on the basic overarching elements of civil liability in Brazil. I cannot recommend that video highly enough, but I'm here today to address a specific and very interesting topic, which is product liability. These disputes range all the way from claims filed by individual consumers to high-stakes, complex litigation brought by the public prosecutor, by not-for-profit organizations, etc. There is a plethora of questions, both on the procedural law and on the substantive law, that warrant discussion. But if I were to pinpoint one specific question that I would ask, it would be this one. What statute will the courts actually apply to my case?
That is an important question because Brazil has a civil code, but also a specific Consumer Rights Act known as Consumer Defense Code or CDC. Indeed, the CDC is much more favorable to claimants than the civil code for a series of reasons. Let me highlight two of them. First, the Civil Code leaves the door open for inquiry into whether respondent acted in a negligent or reckless manner. That point is moot under the Consumer Code as it provides for the strict liability of suppliers. Second, the burden of proof may change. It is a basic rule across multiple jurisdictions that claimants must provide courts with evidence of their factual arguments. However, the Consumer Code provides for a shift, and it is the supplier who must prove that its goods or services are not defective, or that the damages suffered by the consumer resulted from another set of facts unrelated to its goods or services. And there is more, such as different time limits to bring a claim, different rules to interpret contracts, and so on.
Right. Courts will usually apply the Consumer Code without further thought, but that by no means is a no-brainer. Under certain circumstances, a defendant may credibly argue that the Civil Code applies and shall govern the dispute because its relationship with claimant is not or does not qualify as a consumer relationship. And I'll give you one example of this, which has to do with cases involving the wrongful death of a consumer. Indeed, in some countries, the estate of the victim can bring a direct claim against the supplier, but that's not how it works in Brazil. In fact, here, the estate will not have such standing. It is the close relatives of the victim, the consumer who died in the accident or the event, who may bring the claim. But note, in doing it, they are not pursuing the damages suffered by the consumer who died. They are pursuing their own damages. They seek compensation for their own pain and suffering, the loss of income that they had, which is why it is the Civil Code rather than the Consumer Code which will apply. But anyways, even if the Consumer Code applies, that still does not mean that a claimant would automatically win the case, for instance. Much to the contrary. And this is a very common misunderstanding. The larger the dispute, for instance, those cases brought by the public prosecutor, the worse the consequences are. Indeed, my colleague Marcela just mentioned a defendant may prove that its goods or services did not have the flaw, the defect, that claimant attributes to them, or a defendant may prove that the damages suffered by that claimant did not result from those goods and services. Rather, they resulted from a different set of facts, for instance, a third-party conduct, so there is no causation. Thank you, and please do watch the other short videos of this series. Goodbye.